here, and this is going to be a rather short video. There was a hearing that took place on April 4th, Thursday, April 4th, so we are going to just rewatch it and see what takes place. I'm actually going to put on my channel, I have read all the motions, so there's going to be in my video regarding this, the Commonwealth, the people fighting back against the Commonwealth. So there is a motion that was put forth by the Commonwealth. They want a buffer zone of 500 feet around the courthouse. That includes private homes and businesses and all sorts of the public areas like the library are within that 500 feet buffer zone. And they want this buffer zone where no one can wear anything, any apparel, they can't say anything, they can't do anything, they can't have anything in any way, shape, or form related to supporting or being disrespectful to either side. So it's pretty broad. And basically there were arguments from the citizens that came forth, and so a couple of citizens put some funds together. They raised some funds to hire the attorney Mark Randazza to fight for the First Amendment, because literally the Commonwealth is trying to take away the First Amendment from the people in that community. So with that in mind, we are going to watch, oh, and additionally, the ACLU also put forth an Amicas something, I can't pronounce it, but it's basically just like an informational, here's a little information we're giving you about case law and what you should know about this particular issue and how it's been handled in the past. So it's really more like a helpful third party neutral person who is like, you know what, this is kind of some information that might help you out to when you make your decision, judge. So it's basically for her to read. So she will reference that just in case you were wondering. So let's get started with this. Please be sure to like this video, subscribe, comment, do all the YouTube-y things. I appreciate it so much. I appreciate you just being here. All right, so let's get started. We're going to listen to the hearing. It's not very long, and you'll see why.
Court, all rise, please. Yea. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court in the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
That was normal. I thought I had it on like 1.5 speed, because I usually listen to things on 1.5 or 1.75 or even faster sometimes, just because that's my normal, like, I'm going all the time in my brain. But so I seriously thought that it was on 1.5 speed because that guy was talking so fast, but it wasn't. This is normal speed.
Judge, this is 22 CR 117.
Reminder, this does say up in the corner, it says live. I put the captions there so it kind of covers that, but this is not live. This is a rewatch that we are doing right now. I got this from Boston 25 News, their channel, and I'm commenting. So we're using this for, you know, educational purposes.
Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Adam Lally for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Tanis Yannetti representing Karen Reed.
Good morning, Ms. Yannetti. I'm told that David Yannetti's held on trial somewhere else.
He is, Your Honor.
Okay. And good morning, Ms. Reed.
So she is David Yannetti's sister. They work in the same firm. I believe there might be like partners, or at least they, you know, they work with one another, and she is totally up to date on this case, at least as much as she needs to be for these hearings that she's standing in for him, because he is in trial.
All right, so first and foremost, housekeeping. Mr. Lally, what is the status of the DNA?
So, Your Honor, the status of the DNA is I spoke to the lab a few times over the last.
FYI, there's still DNA that testing has not come back for, and this, I believe, is for the hair that they found on the inside, like the headlight thing of Karen's car, which I just find so unbelievable. So they're doing DNA testing on that. I think that's what the DNA testing he'll say in a minute. Just as a reminder, this is April 4th that this is being recorded. They are, and that they had this hearing. So it is like a week and a half away, not even, for like literally 7 business days. 7 business days from now, we're going to trial, and we still don't have any DNA results. So let's hear what he has to say.
Couple days, they actually were able to stay late last night and finish the mitochondrial portion in regard to seeing if they were able to generate a profile from the hair sample.
Can you hear him, Ms. Yannetti?
I would actually prefer, Your Honor, if you would take the
Or
podium.
just,
Fine.
yeah.
So, Your Honor, just to begin again, so I've spoken to the lab a few times over the last week or so, including this morning. So they were able to stay late last night and finish to see if they could generate a mitochondrial DNA profile for the hair sample.
Yeah, so the hair sample they found on the bumper or whatever that stayed in place for all the many, many miles and the blizzard-like conditions that Karen Reed was driving around in that morning. I don't believe it. And it's supposedly still there from, according to them, like around midnight when she hit him. So I don't know. But that is the hair that they are discussing. And again, 7 business days from trial.
I was informed this morning that they were able to generate a partial profile. They're still in the process of seeing if full profile can be generated, but they've begun the process.
Also, I just want to point out, Aiden Carney, Turtle Boy, is right behind Lally. You could see his head kind of poking out right there. He's going to make some awesome faces. Pay attention to him. He's funny.
Of generating a profile from the sample from Mr. O'Keefe. As far as I'm a little unclear, and I responded with some questions just for clarification purposes, because I'm a little unclear of whether or not a partial profile would be something they could do a comparison with in regard to the mtDNA. And then I'm also inquiring as to, so initially what I've been told is that if they were not able to generate a profile, I would have a report on that by the end of next week, and that would essentially be the end of it. However, given this development, I'm not sure, other than they indicated that any sort of report regarding a comparison would likely be sometime after April 16th, and then obviously I asked for clarification.
So he won't get the report until after the trial starts, because the trial starts on the 16th.
Clarification, and I'm still waiting that as far as what after April 16th means, as far as are we talking about, the week following or a month later, or what the situation is. So unfortunately I don't have a ton of clarity, but at least I'm able to tell the court that they were able to generate at least a partial profile from the hair sample.
All right, so trial starts a week from Tuesday.
Mm-hmm.
I would entertain a motion to exclude the DNA. All right, so let's move on to what we
Understood.
have here. All right.
No DNA for you, Adam Lally. You cannot. Let's look at Turtle Boy's face when she says that. I just want to watch his reaction if we could see it.
All right, so let's move on to what we
Understood.
have here.
Oh, wait.
The DNA. So trial starts a week from Tuesday.
Mm-hmm.
I would entertain a motion to exclude the DNA. All right, so
Oh, you
let's
can't
move
see
on
him.
to what we
Understood.
have here. All right, so
Oh, I don't know. Yeah, so,
I
anyways.
will hear from the
Keep going.
Commonwealth. On your motion for a buffer zone
Buffer zone.
and for restricting clothing.
Did you see? And for restricting clothing. Like, come on, buddy. Let's watch that again. That was funny.
I will hear from the Commonwealth on your motion for a buffer zone and for restricting clothing.
Thank you, Your Honor. So the Commonwealth would ask that the motion be allowed for a number of different reasons. Essentially, what I would submit to the court is that this is not, as the court is well aware, this is not a novel approach. This is something that's been done in other cases and done specifically in other cases in this courthouse. What the Commonwealth would submit is what's been proposed to the court is an entirely neutral motion, and that it applies equally regardless of viewpoint, regardless of content of signage or clothing items or anything else. The motion the Commonwealth filed is not in essence about any sort of protesters or any sort of presence in regard to them, but more about the jurors and about the jurors' freedom to be free and to come and perform their civic duty free from extraneous influence. We need in this case, obviously, as the court is well aware, a fair and impartial jury. And this is something that extends beyond just the impanelment of that jury. As the court is well aware, as the court asks questions or inquires of every jury in every case multiple times a day about whether or not that they've been exposed to any sort of extraneous influences, or if they've gone online, or if they've seen things on social media pertaining to the case. And
Yeah, and at that point, they've made a vow to say that, I'm going to adhere to the court's orders when I'm not in this courtroom. And when I'm in the courtroom, too. But, when I'm not in this courtroom, I'm not going to be looking up news articles about it, is what you agree to as a juror. So, to not be influenced easily by, other people's opinions or whatnot. You have to take everything all into account.
the question I would ask is, how is a juror supposed to truthfully answer that in the negative when they're bombarded with it every single time that they walk in and out of this courthouse? It's not asking for a restriction on free speech or to infringe upon someone's First Amendment right. Protesting is going to happen, that's fine. It's just where it happens and how it impacts the jury in this case is what the Commonwealth has concerns about. Another analogy I would make, Your Honor, is to the voting place restrictions, another fundamental right in which there are restrictions as far as signage and footage away from the voting place of how close you can be, that they're not allowed inside the building with signs related to whatever specific candidate you're supporting. You can't go in the voting booth next to somebody, take your candidate's sign and shove it in somebody's face while they're trying to exercise their right to vote.
And I get that. And I don't think anybody's planning on bringing signs into the courthouse. But, I mean, I may be wrong, but most people want to stand outside and rally together, peacefully protesting the law enforcement and the district attorney and Judge Cannoni herself for whatever bad ruling she makes. I mean, they have every right to do that. And what better place to do that in the place where it's happening and where you can make an impact by being out there and having a sign up.
Essentially, what this motion is asking is or seeking to protect is the freedom of the jurors who are called upon to execute their civic duty unfettered from extraneous influence. We're not asking the court to restrict the media or anyone's access to the media. And I would note anecdotally that within this courthouse over the last year plus, there have been several instances in which jurors on completely unrelated cases have had to receive instructions from the court and been impacted by the activities related to this case every time that it's on. Lastly, what I would submit to the court is really any opposition, or at least the ones that I've seen as far as an amicus, essentially, the reason for the opposition is because there are parties that want to try and see if they can influence the jury inappropriately in this case. All we're asking for, Your Honor,
He just said there are parties involved in these motions arguing back because they want to interfere. You have to prove intent. You have to prove that they actually have an intention to interfere or impede the justice system or sway the jurors' minds, which none of them are trying to do. I don't understand why everything is such a fight with this Commonwealth. They make me cringe so much. This is such a just egregious overstepping of power to try to put a buffer zone of 500 feet in your city for protesting because you don't like the message. Let's be honest, that's what this is about. The Commonwealth doesn't like all the heat that they're getting because it's pushback on them and how crappy they did investigating the work. But not only that, they're being accused, they're people in the group are being accused of corruption. And rightfully so, because from what we're seeing, Trooper Proctor was lead investigator, pretty much best friends with Brian Albert, the homeowner. I mean, they're like family, so better than best friends. Trooper Proctor's mom said that the Albert family to them is like family. So, there's that. There's just so much. Anyways, I could go on and on for talking about this case, but I'm gonna let the hearing continue because I promised you a short one.
All the Commonwealth is submitting in whatever
Shorter.
form or modifications the court deems appropriate based on the Commonwealth's proposal. But what we're essentially asking for is to allow the jury to execute their duties in this case, both during the impanelment process and throughout the course of the trial as they're hearing evidence, and not be subjected to extraneous influences, regardless of the viewpoint of those extraneous influences during the course of the exercision of that duty. For those reasons, the Commonwealth would ask that the motion be allowed.
All right, thank you. Ms. Unetti?
Thank you. Your Honor, I have three things that I would like to put on the record for this court. First, please note that we do not control these protesters. This has been an organic movement that arose because ordinary citizens were made aware of the case and apparently agree with us that the prosecution of Karen Reed is unjust. Speaking out against injustice is a fundamental American right. My client is appreciative of the support that she has received and continues to receive, but we in no way dictate or instruct anyone to do anything. These are strictly citizens invoking their right to free speech.
Yep.
Second, while we question whether the Commonwealth's motion is constitutional, we are taking no position on this issue. In our view, this is between this honorable court and the general public. It is between...
And I share your view. I think this is something that frankly could have been done administratively, but I wanted to give the defendant an opportunity to be heard. So you're not taking a position on it?
No, we believe that this is between the Commonwealth and the Constitution.
Who is this cameraman? They keep zooming in really close to their face and then zooming all the way back out again. So you never even see them except like their forehead. This is funny.
In this honorable court and the general public. And that while the ACLU has filed something, members of the public have filed something, they will speak to the constitutionality of this. And other than receiving our sympathy and our blessing, we are not joining in their argument. Again, we're taking no position. And I want to make clear that our intent is and always has been that we are going to win this case inside the courtroom. Your Honor, that is what we're going to do. We're going to win this case inside the courtroom. And with that, I'll waive further argument.
Okay. So I have received something styled a citizen's motion to intervene. And I think criminal counsel surely knows that unlike civil, there is nothing in the Mass Rules of criminal procedure that supports intervention in a criminal case. But I've read the memo. I received it yesterday, and I've read it. I am not going to hear from counsel.
And then she moves on. So some citizens that are often at these rallies who want to continue to have these rallies and express their freedom of speech have raised enough money to hire Mark Randazza, an attorney, who really is passionate about First Amendment rights. He put together a beautiful motion. I read it in another video. I did all of them all in one, so it's a lengthy video. But there are timestamps if you want to go see it. So I read that, and it's a really good motion and very powerful. There were a lot of things that, I agree with. I'm passionate about the First Amendment too, so it drives me insane when there's like gag orders and things like that. But, anyways.
I do want to say, and quoting the appeals court, intervention is a concept foreign to criminal procedure.
So the guy Mark Randazza, who was hired, they spent all this money to hire him and do this motion and to have him here at this hearing to speak if he was given the opportunity to. But she said no. So they spent a lot of money to get that out there. But you know what? It's a public document now, and it's on the record, and it can always be appealed. So.
Now, apparently the Civil Liberties Union of Massachusetts, understanding that, filed a motion to file an Amicus Curiae memorandum. So
Curiae.
that motion is allowed, and I have read the ACLU brief, and frankly, I find it very helpful, and I've been persuaded by many of the points in there. So I don't need to hear from anybody, and the ACLU, I think, did a great job in their memo, and I understand their position. So it's undisputed that under our system of government, the people's right to protest is preserved under the First Amendment, as is the free expression of their views. I have to consider, of course, this very important constitutional right, but the bedrock principle of the trial court is assuring a defendant, it is and it must be assuring the defendant a right to a fair trial, which includes a right to a fair and impartial jury, which by definition is a jury free from any outside influence. So my focus has to be on having this jury hear the evidence and the law and decide this case based solely on the evidence and the law that is heard here in this courtroom. I have to balance the rights of protest. The law is very clear on this. Sometimes these are competing interests. But in balancing them, in weighing all the factors, I do find that an external buffer zone is appropriate and that we do need prudent regulation on in-court expression. But the 500 feet is far too excessive. So I recognize that my obligation is that I must reasonably accommodate the rights of all people to protest in a meaningful way, while ensuring, above all here, that this case is decided fairly based on the evidence without any undue interference from outside pressures or influence in accordance with the law. And that's what I will do. So I will have a written order and a very short decision on this by tomorrow, but hopefully by this afternoon. So I will see you all next week. And I intend to go through all the motions in limine on Friday. I would like council to consider how you want to do impanelment. If there is a request for a questionnaire, it needs to be a supplemental questionnaire. Council need to work together. It needs to be one side, one page, two sides, no longer. Council works together, and if you cannot agree on a questionnaire, then part one of the questionnaire will be what you agree to. Part two of the questionnaire will be what the Commonwealth wants and the defendant objects to. And part three will be what the defendant wants and the Commonwealth objects to. And it must all be on one page. So I'll see you all next Friday.
God, I hate when my dog barks. She's so loud.
Goodbye.
I apologize for that because it was loud to me and it always like gets my heart jumping when she barks like that. I hate it. I hate it. Oh, sorry. Okay. So, there we have it. We just heard the hearing and there wasn't a whole lot to it, but we do know now that Judge Canoni is on the side of let's putting a buffer zone in, but just not 500 feet because that's way too much. And I agree. If you want to know more about the buffer zone and the other motions that were filed, I go through all three of them. So the motion by the Commonwealth, the motion set forth by the citizens, and then the ACLU memorandum, the Amicas Curiae, right? Is that how you say it? Curiae. Okay. Amicas Curiae. I need to learn these things. Okay. So with that, I will let you go. There is another hearing Friday, next Friday. So the what is it, the 12th, whatever day the Friday right before the trial starts. So trial starts the 16th, and that's a Tuesday, and so the 12th is a Friday. That is when the next hearing is, and she's going to go over whatever outstanding things they have and going over jury forms and whatnots. So that's probably not going to be a very exciting one, but if there's anything substantial that comes out, then I will cover it and do a recap as well. So thank you so much for watching. Don't forget to like this video, comment, subscribe, and thank you again. Take care. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.